Everyone. I am delighted to welcome you to this session within the SCC Arbitration Week, the fourth actually. And we are very happy to have you here. Today we are going to discuss arbitration costs and the cost for resolving disputes. Today, we're also launching a new report, a new SCC report on the costs of arbitration and their apportionment. And this is, of course, a very interesting question for everyone who is a party to an arbitration or a litigation for that matter. We know that parties are well aware of the significant benefits of going to an institution to do an arbitration in comparison to going to court or to ad hoc arbitration. But we also know that more and more parties are questioning the cost. It's perceived to be more expensive today than it was 10, 15, 20 years ago. And why is that? So we had a look at the numbers. We did this first time in 2016, and we did it again this year. And that is the report we are going to look into today. So we saw that parties are often unaware of the costs and which costs are being associated to different parts and different phases of a proceeding, of an arbitration or a litigation. And we also saw that the clear majority of costs are manageable for the parties. So the cost will, of course, depend on the size of the claim, the size of the arbitration. But the largest part of the cost that associated to the legal representation for the party, that is largely depending on the strategic choices the parties take during the proceedings. So our aim of this report and this panel discussion, this event we have today, is to give both parties but also counsel foreseeability in relation to cost and give them all the possible tools to get the proceeding they need or they have to get a proper dispute resolution. I'm delighted to introduce Jake Lowther. He is the main author of this report and also specialist counsel at the SCC. Jake will give us the key insights, short introduction and the key insights into this report. And after that, we are going to be joined by Tobias Hamrin and Lotta Knapp-Lönnroth at this stage. And Tobias Hamrin is a partner at Delphi Law Firm, focusing on dispute resolution. Lotta Knapp-Lönnroth is senior legal counsel at Perstorp Group, and she has a background in complex litigation and arbitration. So stay tuned. Well, thank you for being here, and without further ado, welcome, Jake.
Thank you very much, Caroline, and also for the opportunity to be involved in this report. I'm very much looking forward to presenting some of the findings with you today, and of course, as part of the SCC Arbitration Week, to being part of the discussion on how we can do arbitration in the best, most efficient way possible. So as Caroline's already mentioned, we are today very pleased to be launching to the market this 2024 report on the costs of the arbitration, but also on the apportionment of the costs under the SCC Rules. As Caroline mentioned, and will probably become apparent during this presentation, while I am the main coordinator and author of this report, I could not have done it without the support of some of my colleagues, two former members of the SCC Secretariat, Lorenzo Nizzi and Samuel Herberg-Delak, who was also with us during the 2024 year. So when we're talking about the costs of the arbitration, it's first important to understand, what does that actually mean? What are we referring to when it comes to the costs of the arbitration? Under the SCC Rules, Article 49, the costs of the arbitration consist of, firstly, the fees of the arbitral tribunal, secondly, the administrative fee to the SCC, and finally, any expenses of the arbitral tribunal and the SCC. For example, this might be hearing costs or other hearing-related costs. And how do we determine, how are those fees calculated? Well, the rules go on to explain that the fees of the arbitral tribunal and the SCC's administrative fee, as well as a reserve amount for those potential additional expenses, are calculated on the basis of the amount in dispute. What is it that the parties are claiming on potentially counterclaiming? And then, in line with the SCC's table of costs, which form part of the SCC Rules, we then come to a number, the costs of the arbitration. And this is a mathematical formula based on varying intervals, up from 25,000 euros to 100 million. And where you have cases involving an amount in dispute above this figure of 100 million euros, then the board, the SCC board, will determine the amount, the cost of the arbitration at its monthly board meeting. And this is determined on a case-by-case basis. As Caroline mentioned, the 2024 report is based on a report that was released in 2016. And I remember even then that discussions about arbitration were very focused on these perceived criticisms, particularly internationally, about how much is arbitration costing the parties, the users, and is there value for money in this process, as well as are things taking too long. And the SCC back in 2016 released a report covering the period of 2007 to 2014, and in response to this this criticism of perceived increases in time and cost. And it was authored by by former legal counsel here at the SCC, Celeste Salinas Cuero. And in that report, the author had looked at approximately 85 arbitral awards rendered on the SCC Arbitration Rules. That is to say, not other versions of the SCC Rules. The SCC offers a number of different rules, including expedited rules, rules for the SCC Express, mediation, and so forth. And when we're looking at the cost of the arbitration, the report was delimited to the SCC Arbitration Rules. To put it into context, the 2024 report considers the period immediately following, so 2015 to 2022. And in that period, the SCC registered a total of 1,428 cases. That is to say, under all of the rules and services that the SCC administers its cases under. And of those, 1,304 arbitral awards were rendered under the SCC Arbitration Rules, or 1,304 cases were administered under the SCC Arbitration Rules and the SCC Rules for Expedited Arbitrations. Out of that number, approximately 221 arbitral awards qualified under the same parameters, under the same delimitations as the 2016 report. And I will discuss that in a second. Of that 221 number, 151 arbitral awards were rendered under the SCC Arbitration Rules, the majority of which, 104, were decided by an arbitral tribunal composed of 3 arbitrators, and then 47 by a sole arbitrator. The remaining 70 were determined under the SCC Rules for Expedited Arbitrations. Now, to those delimitations, we have followed exactly the same delimitations as in the 2016 report to ensure the most accurate possible comparison is possible. And in line with that report, we have excluded arbitral awards that were rendered during the 2015 and 2022 period, where there is not full information on the parties' claims for costs for legal representation, where there has been an award of consent, and where the arbitral tribunal has recorded the termination of the proceedings in a decision. And if we look now to some of the key findings from that, from this 2024 report, we can see that amongst the cases that were from this period and that make up the 2024 report, we have 37 cases in which the amount in dispute was less than 500,000 euros, and then 13 between 500,000 euros and 1 million. 51 jumping up to in between 1 million euros and 5 million euros, and then 9 cases that were of a disputed value of between 5 million and 10 million, 28 between 10 and 50 million euros, 50 million and 100 million euros. There were 6 cases in total. And then finally, 7 cases over this 100 million euro threshold where the SCC board took a decision on the costs of the arbitration. And when we looked further into the proportion of these costs, what do the costs of the arbitration compared to the legal costs of the parties, how do they compare? We see that a total of 93.1% of the total costs paid by the parties corresponded to the costs of legal representation, whereas a mean of 6.9% was the amount paid by the parties for the costs of the arbitration itself. So these costs under Article 49 of the SCC Rules. And then if we're looking at, and this was with the sole arbitrator, and then if we're looking at the total costs with an arbitral tribunal comprised of 3 arbitrators, there a mean percentage of 92.8% was paid for the costs of legal representation, and the remaining 7.2% devoted to pay the costs of the arbitration. Now, as I mentioned at the outset, in this 2024 report, for the first time, we are considering the cases also rendered under the Expedited Arbitration Rules. The SCC's cases are very varied and diverse, and in comparison to many other institutions, over or almost a third on average over the past 5 years of cases administered by the SCC have been under the SCC's Expedited Arbitration Rules. And as you can imagine, given that these are expedited cases, we have a lower amount in dispute compared to the arbitration rules. And in that case, only 7.1% of cases concerned an amount of over 1 million euros. The median amount of in dispute was 139,151 euros, and the mean amount was 321,883 euros. And based on the statistics that we have uncovered in our report, the median costs for legal representation were 6 times higher than the median arbitration costs. And then the mean costs for legal representation were 10.6 times higher than the mean arbitration costs under the Expedited Arbitration Rules. So when we are considering the reports come next to one another, side by side, what kinds of conclusions can we draw from these 2 reports? Well, as is probably not too surprising, given the amount of time that has passed between the reports, inflation and so on and so forth, the amounts in dispute appear to have slightly increased over time. The costs of arbitration, however, now represent even less of the parties' total costs when going to arbitration. And the costs of legal representation are currently, based on this analysis, between 5.9 and 4.1 times the costs of the arbitration. We've noticed that the SCC has in general become more time efficient. Some of the reasons that we explain this is through our efforts to improve innovation and digitalization of the arbitral process. So innovations such as the SCC platform, where all of our case communications and all of the party submissions and documents are loaded to an online platform, is one way in which the parties have directly in this time period been provided greater opportunities to save time and costs. And in addition, during this period, at the very end of the 2016 report, the SCC introduced its internal digital case management system. And this allows us to take, of course, to improve on time and cost efficiency when it comes to the administration of cases by the SCC Secretariat. When we are continuing the comparisons between the reports, one of the questions, as outlined at the outset, is this question on how are arbitral tribunals, how are decision makers in their cases deciding on the apportionment of the legal costs, of the arbitration, including the legal costs and the costs of the arbitration. And in general, we have seen an increased trend towards a winner-takes-all approach, where the successful party is awarded its costs in full, which suggests also that there has been a slight harmonization of the practices between domestic and international cases. We've also noticed that, based on the data collected, that the SCC and Swedish arbitration in general has become more international. More international arbitrators are being appointed in these cases, more international parties. And the final figure from this particular pool of cases is approximately 53.6% of cases were international in this particular pool of 221 cases. And as mentioned, it's a more diverse pool of arbitrators. Fewer Swedish arbitrators and more arbitrators from around both the region and internationally are deciding on these SCC cases. When we are considering the conclusions of the 2024 report when it comes to the SCC rules for expedited arbitrations, of course, we do not have the data to compare in the expedited cases on the basis that the original report was delimited to arbitration rule cases. And in this particular report, we've decided to also include this information simply because there is a large number of cases that the SCC administers under these rules, and we considered that it would be an interesting question to also consider: is there a difference in the practice? Is there a discernible change between the statistics when comparing cases administered under the arbitration rules with those administered under the expedited arbitration rules? And based on our findings of the pool of qualifying arbitral awards, we do note, and perhaps unsurprising to our Swedish listeners, is that the caseload is more domestic when it comes to the expedited cases. But that also the SCC's model, that the SCC's dispute resolution clause, our so-called combined clause, where the SCC, if the parties do not agree on which rule shall apply, will make a decision based on the amount in dispute and other factors when determining which rule should be applied. But most importantly for the SCC, we have noticed clearly that the timeframes in the SCC expedited arbitration rules are met, that we are seeing cases being administered in a timely fashion, and that the deadlines of 3 months to the final award are are in general being met by arbitrators, which is a very positive conclusion. And in terms of some final remarks, it's, of course, a work in progress that arbitration continues to be a method of dispute resolution that is both providing an access to justice, but also ensuring that the parties' business needs are being properly met. And we at the SCC are continually reviewing what services we are providing and what the needs of the users are. And we are endeavoring to ensure the SCC will continue to monitor the issue of costs and, where possible, to enhance the confidence and transparency of arbitration, both here in Sweden and internationally. And this to ensure a better process for our users, for the users of arbitration internationally, and also maintaining an appropriate level of remuneration to our arbitrators. And by doing so, we are ensuring, to the best of our abilities, a maximum efficiency of time, cost, and quality. And whilst we're on the topic of what the SCC continues to do, our continuing developments, we would love to see you subscribing and staying in contact with us, to communicate with us, to get in touch, and so to please follow us and our latest news. We have here a QR code for you to scan, and of course, if you have any questions, we are always available to answer questions, and you are more than welcome to reach out with your questions, whether it's about this report or other services of the SCC, and what we can do to ensure a better process for our users.
So we are now transitioning into the second part of this today's session at the SCC Arbitration Week. And I have been joined by Tobias Hamrin, partner at Delphi Law Firm, Lotta Knapp Lönnroth, Senior Legal Counsel at Perstorp Group, and Specialist Counsel at the SCC, Jake Lowther.
Still here.
Still here, yes. So great. We have all read the report and listened to your introduction to it. And my first question would be, were you surprised? Are there any surprises or anything you didn't foresee? If I start with you, Jake, what did you feel or any surprises?
It's a very good question. Of course, when we were looking at the data, you're hoping for certain conclusions to perhaps be more clear. And I'm particularly pleased by the fact that it appears that the costs of the arbitration are indeed staying, very much within the bounds of what we would consider to be reasonable, and certainly are becoming a less large proportion of the overall costs for the user. There were some interesting things coming out of certain cases. For example, one case, we won arbitral award in the costs decision. What actually affected the decision there was the behavior of the parties. And in that case, where one of the parties had rejected a settlement offer, and in that case, the settlement offer was actually approximately near to what the arbitral tribunal ultimately decided, and therefore it could have saved time and costs if the parties had been able to reach an agreement prior to the rendering of the final award. So perhaps one surprise or one interesting thing to come out of the report is just how arbitral tribunals are considering this question, and it's not simply some kind of a rubber stamp decision, but rather what is happening in this process and how can we ensure the best value for the users as well, and promote perhaps better practices.
Exactly. Any surprises from your sides?
Yeah, I must say that I was surprised and pleasantly surprised that the time to render an award was within had actually decreased, and that all even though the costs of the arbitration, including the counsel fees, had increased. And I have the feeling that the same does not apply for litigation in courts, where commercial proceedings usually take longer time. So that's a pleasant surprise from the parties' perspective.
No, I agree, completely agree. And Tobias, anything from the council?
I agree with you too there, Lotta, and that compared to litigation, litigation takes more time, and I'm not surprised actually at most of the conclusions here with regard to arbitration, because I think that is in line with my experience, and I think maybe a general perception too, that the costs of the arbitration are relatively minor as compared to the legal fees, the parties' legal fees, and it's also my impression that the arbitration, at least with the SCC, they are normally within the time frame, I would say. So not so surprised.
So no surprises in the report?
but actually, no, but I mean, that is just a general perception and what people are saying. And I mean, this is very interesting, I think, to actually get the statistics to know, because what people are saying is it's not always right?
No.
So I think it's from that perspective, it's very exciting, I think.
And if I can add, I was also a bit surprised that there's a larger number of international arbitrators, especially seeing SCC's history, of course, being an international arbitration institution, but also having a large pool of Swedish arbitrators. But I know that you've been working a lot with the diversity, both in relation to gender, but also in relation to nationality, and you can see that from the report.
Yeah, that was for me a very pleasant surprise. Not only that the time, the duration of the proceedings were shorter in this report than in the previous report, but also the nationalities. We see many more nationalities at the SSC today than 10 years ago. Perfect.
And I can, sorry, Jake. I can also add that I think I'm not surprised either about the popularity of the combination clause, because I think myself it's usually a very good compromise, and it works very well, I think. So I'm not surprised by that either. But again, good to see.
Yeah, and that was the first time we actually had some statistics on the combination clause, that we actually saw that it is, well, the gut feeling from us at the Secretariat is that we see it quite a lot, but now we have statistics to actually show that it is well used, at least in Swedish contracts, not as much in international contracts. And if we maybe take a step sideways, and costs in general, and this is a question for you, Lotta, as a party representative here, but how important is it to have a cost efficient or to have low costs for resolving a dispute from a party perspective?
Yeah, good question, and a very central question, of course. And I must say, managing cost is always important, but the financial aspect of a dispute is not always the most important factor. It can be protecting market share, brand, innovations, or maintaining key relationships. So that can vary, and in my role, that's probably the most important aspect to grasp and to understand. But from an in-house counsel perspective, it's always, of course, important to have a budget and to adhere to that budget to make sure that it's maintained, because you have to stand up for it internally. And in cases with very large the cost, it can impact the company's bottom line. So that's, of course, important. And you have to make sure that the legal cost actually corresponds to the value that the dispute itself brings to the company, so that there's the right amount of correlation in between. So in a nutshell, it's very important.
Yeah, and maybe that's not a surprise at all.
No.
We have talked about that for a long time. But how, so from your counsel perspective, Tobias, how would you say that how are you handling that? Is there any, I know that you counsel are more and more asked to provide budgets, to provide estimates for the arbitration or the litigation in total and so on. Are there any other ways for you to help out the in-house legal counsels to keep to budget?
Yes, I agree with that. I think it's becoming more and more common that you have you give estimates, and I mean that is always a delicate subject, of course. And what are you actually estimating for? What is to be included or not? And that's a large discussion, obviously. And there are different ways that you can handle that. I think of course, I think the best solution is some kind of where you have milestones, or you have estimates for fixed steps, and then because then you can actually, then it means something. To have an estimate for the whole arbitration, it's very difficult. And I think all those, and then you can look at different arrangements. But I think what it really comes down to is that you have to have sort of a balance of risk for both the party and for the law firm, basically. So that it's beneficial to both parties in that sense. And I also think you made a very good point there, Lotta, with what is the objective actually of what we're trying to achieve here? Because I think sometimes you get some kind of mission creep. You might have, I mean, there are many reasons for going into arbitration, and not all of them are win at all costs. But after a while, it tends to be win at all costs. Yeah. And I think that's very important to have a common mutual understanding from the beginning to what are we trying to achieve here, and what was the reason that we initially initiated this.
And very often that reason can be to find a settlement.
Absolutely.
In not too far ahead in the future, of course. So Jake, so how can institutions support parties and counsel in keeping the costs low, would you say?
Well, I think, as I mentioned in my presentation, one of the key things that we at the SCC have done is really to try and maintain that dialogue as much as possible to find out what are you actually needing from an institution. And I'm sure we'll be talking about how both the legal counsel and the users can think perhaps more about which is potentially going to be the right tool for the right for a potential dispute arising out of this contract. But as I also mentioned, you know, one of the advantages of arbitration is we have this flexibility inbuilt compared to the court system, which of course fulfill a slightly different function, related but slightly different. And so we have some flexibility in how we put it together, how we administer. And one thing that we've clearly been doing for a number of years now is how do we streamline this process? How do we find further efficiencies, both time and cost, without any kind of compromise on the quality of an ultimate award? And it's maintaining that dialogue, I think, that is key, but also keeping aware of developments in how to best manage the process.
No, exactly. We have already discussed combination clauses, which is a way to really find the most proper, the most suitable method to resolve a dispute. But is there anything else you as a party representative think about how can you make sure when you enter into a contract that you have a proper method to resolve disputes in the future?
Yeah, it's a really good question, and I think it's often a question that is not really given enough time and thought when you negotiate a contract, because of course you're never going to enter into a dispute, right? But I would advise to take a moment to think about what kind of dispute could actually occur. And now we're talking about commercial B2B disputes, and there I would always opt for arbitration. But looking into, of course, combination clause is, in my opinion, a very good alternative, because it's difficult to know from the beginning how big the dispute will be. Will it be a very complex dispute? Then you perhaps don't want to be stuck with an expedited arbitration clause. Will it be a very quite streamlined dispute? Then you would save both in time and cost on having an expedited arbitration. So that, from my point of view, that's a really good option. Then my second point would be, I'm a big fan of ADR, Alternative Dispute Resolution, but I would be hesitant to adding a too complicated clause stating too many steps before actually launching the arbitration itself, because that can often give rise to a dispute within the dispute, and it can steal valuable time for the party who wants to initiate arbitration quickly. So I would suggest to just keep it simple and add some flexibility for the dispute.
May I ask a question related
Yes.
to the combination clauses? So we provide several on our website that are, of course, freely available for parties to use. And as I mentioned in my presentation, one of the ones that we've seen, particularly amongst Swedish parties, is where it is the SCC board that ultimately decides which rules shall apply if the parties cannot agree. But there are also clauses where it can be simply based on the amount in dispute. And I understand there are other institutions that it's solely based on this particular threshold. Is there something when you are considering which clauses to use and also advising a client, what might you go with the one over the other?
Personally, I prefer the one where I leave it up to the SCC to make the decision, because they have, or you have, such good insights into what makes a dispute complicated and what makes it fairly straightforward. I mean, it's not always about the money, the claim at hand, and how big the claim is. It can be other factors also that makes the dispute more complicated. And to have that extra assessment rather than to solely focusing on how could we up this claim a little bit to get into the direction where we want to be? I think it gets to a better result in the end, in my personal opinion.
I totally agree with you, Lotta. It's the numbers don't always tell the full truth, and it's good to have that option to let someone have a look at it. How complex is this really? So I just agree.
Am I correct in my gut feeling is that we see combination clauses mainly in Swedish contracts, and that we combination clauses on complexity where the SCC gets to decide which rules to apply, and that we see value-based combination clauses mainly in international contracts. Is that correct?
I think that's a fair, fair assessment.
Yeah, because some institutions offer mandatory value limits for the different rules, and that is not what we do at the SCC.
Yes, we have a specific opt-in approach to using the expedited rules, and this is something that surprises many of our users, I think, when we are discussing on our roadshows abroad, well, how do I choose this? Well, I mean, you need to. It's not simply by choosing the SCC to administer that you will automatically be administering, that we will be administering under the expedited rules. So explaining how that works, is often quite interesting to an international audience.
So we know since the last report in 2016, and we know from this report as well, that setting the right strategies to not complicate matters more than they need to be complicated is fundamental to keeping a cost-efficient procedure. But what would you say, because it's easy to say for us from our institutional approach that don't complicate too much, don't write too long submissions. Do you really need to submit this exhibit too, or is it enough? When is it enough? But maybe I direct this question to you, Tobias. How do you actually do this in practice? Because I know that counsel, we did see in the presentation that a very large part of the total cost relates to the cost for counsel, of course, this time as well. But how do you feel that you are? You have enough support from the client to really not add that next argument to the procedure, or what are your thoughts on this?
It's a very large topic.
Yes,
for sure. And of course, the interesting question here is, why are actually costs, legal fees here, costs, the parties' costs increasing more, and there might be a lot of different explanations for that, and they may of course be different in different cases as well. But going back to your question here, I think again it's a matter of dialogue, it's a matter of communication, it's a matter of knowing why are we doing this. Of course, there are these things that have always been valid as well, that it helps the counsel if you get the documentation in an orderly manner, of course, if you get access to the right persons, and if they know that they will have to devote time and resources to this, and you are allowed to actually do the due diligence of the dispute beforehand, you can front load the case, and all this it's been valid. It's always been valid, and it still is. And and I think, but if you do that, and if you have the right dialogue with the corporate counsel, then you can make these informed decisions whether to, okay, so this, we might ask for discovery, we might throw this extra legal objection in there. Is it worth it? It might increase our chances to win by 5 to 10%. It will cost this amount. If we win, the cost will be on the other party normally. So it's kind of an economic externality, which you don't bear the full cost burden of doing all these things. And so I think this is kind of also one of the reasons what's driving these increased costs, that you may, if you haven't really communicated and made up your mind on these issues, there is a risk that you might end up in an arms race, because each side wants to do that little extra. You turn every stone, and maybe you just wanted to get like an answer to your legal question for a reasonable fee, and then it turns into something different else, or something completely different. So I think, again, going back to what we said before, knowing what are we trying to achieve here, what is our objective, and also having a good dialogue. And actually that corporate counsel understands and is reasonably involved, and to be able to at least discuss these decisions.
Is that generally your feeling, that the in-house legal counsel, the corporate counsel, is sufficiently involved in the dispute, or do you feel that it ends up in your lap completely?
Well, it varies a lot, and I mean I can understand that. One perception is, okay, good, now it's off my. I've given this to you to take care of this. It's away from my table now, from my work desk. But the result gets so much better if it's possible to work together or to have some involvement in it. And then I know there are corporate counsel always busy. They have thousands of things to attend to. But or if it's, I mean, it doesn't have to be like there could be another stakeholder within the organization, but to have access to the right persons and that they know what this is about, I think that is crucial.
What do you think about that?
Yeah, I agree a lot, and just specifically highlighting 2 points which you already mentioned. The one is like the trend of going more and more into the winner-takes-it-all perspective. It's difficult then to decide which stones do you leave unturned. When is it enough? Because, as you said, all the extra work that you're doing, if it leads to you not having to pay anything in the end, then that's good, right? But of course, then there's the balance of also being like fulfilling your duty of care to the arbitration itself, not to be stuck with part of the legal cost. So I totally agree on that. It's a very difficult balance. And to the other point with communication, I also agree, and I think it's from my point of view, it's very good to see that me as an in-house counsel, I can affect the costs of the largest part of the cost of an arbitration, because working together in a good cooperation with external counsel, we can bring those costs down. And I agree with what you're saying about planning for the arbitration and submitting the right persons and documentary evidence at the right time. It's a lot about planning ahead and make sure that the organization is aware of what's coming, because you don't want to go disturb the financial department within the budget process, right? You won't get any good answers. So you have to know in what order to tackle things. And then I think you can get very good result.
Yeah, I mean, even the best lawyers won't win every dispute, right?
Nope.
So, I mean, it's always a gamble. And it's a poker game. You don't know what cards will be turned up. But as long as you know, as you're making informed decisions and taking risks that you have conceded to, And then at least you've made the right decision through the process. You might not always win, or you might not always win fully, but that is doing good business, I think.
What we did see in this report compared to the last 2016 report is that the share of the total cost for the SCC and the arbitrators is smaller these last years than it was previous years. And I know that we have increased the arbitrators' fees 2 times during this period.
3 times.
3 times, sorry. Yes, included the SCC fee, of course. So 3 times, and that is not actually visible in the increased cost for the arbitration in this today's report. And this might actually be a question to you, Tobias. Do you feel that, or is it your perception as well that the work counsel are putting into each dispute today is you put in more hours, more work into each dispute than you did 10, 15 years ago? Or would you say that the increase is actually due to higher hourly fees or higher cost per case?
Again, each case is individual. I would say it might be a bit of both. And of course, we've had the past few years inflation. So, and how much are counsel fees increasing vis-a-vis inflation? But of course, that's also different from different actors. But I think we're also putting more time into it, for sure. I think that, and why is that? Which is, I mean, the other side of, if you have this, you have the arms race, you have this turn every stone, you have this, all that, but there are also other factors that are driving this. And I think what you tend to hear, disputes are becoming more and more complex. And that might be true. I think it's been said for a long time, probably. And so how are they becoming more complex if they are? I mean, but we've had a lot of, lately at least, we've had a lot of geopolitical events. I mean, you got the pandemic, you got the war in Europe and other places, obviously. You got the AI revolution, so to speak, coming. And all of this might, so of course, influence arbitrations in different ways. And so we've had also globalization for a long time, and then maybe that is now decreasing and less cross-border transactions. But I think, so how is this influencing? Well, if you have more complex supply chains, more parties within the transactions, that in itself makes for more complicated disputes.
May I also ask, one of the conclusions that can also be drawn, I think, from the report is that there are actually more Swedish cases being considered in the final data pool. And this could be down to perhaps, you mentioned globalization and other factors. Do you, either of you, experience that Swedish practice has become a little more international? You mentioned document production, I think, for example.
Yes. For sure.
Yeah, I would say the same. I was thinking both about document production and written witness testimony.
Yes.
So it's a lot of extra work that creates, of course, a lot of extra hours for external counsels and making the disputes more complex.
Yes, and I mean, in a way, that's down to, those factors are also down to counsel in a way. I mean, could write shorter. We could possibly write shorter unless it's more complex. But I think yes, those are maybe international trends that are influencing Swedish domestic arbitration. So we have more discovery, but more witness statements. I think that is probably beneficial though for cost efficiency. But again, it varies depending on the context. But also, I think you have this. So is it more complex? But you have like the digitalization. You have so much more information that is available and that you can search in, that you can analyze, that you can present easily. And that in itself probably makes disputes more complex because there is just more to source from, right?
Yeah.
Also, I think the products, I mean, it's different if you have, in a sense, it's different if you have physical products, whereas if you have digital services, it's less tangible. It's a different kind of thing to arbitrate. And you might need the involvement of experts, technical experts. You have to understand what the experts say, right? That in itself. So I think with all these complexities, it's obviously been going on for a long while, and but I think that is not an excuse, but it might be one factor that is actually increasing costs and duration when that is the case. Well, we will see what AI does, if that tends to just make it more complex or if it makes it easier or if it will actually reduce costs. I think just to add with obviously one thing that has probably decreased costs is with the pandemic and the digital hearings most likely is a cost decreasing factor, I would think.
And just to build on that, and I would say that from a client's perspective, we also would expect to see a cost decrease as a result of AI and administration and case handling becoming more efficient. And I know a lot of law firms are starting to use these tools, and look forward to seeing when it's fully more integrated to see where we can gain from that.
It will be very exciting, yeah.
Yeah.
The next report maybe will show some very different findings.
Yeah.
Yeah. So, well, in the standard is of course an hourly fee, but are you looking into different types of alternative fee arrangements? Do you have any feelings about alternative fees?
Well, I think, like I said before, I think you can do that, but you have to it's more of shorter milestones within the project. I think that's probably the best. But you might have, Lotta, what's your opinion?
No, I don't think I have any creative fee arrangement to add, but I can see that there will be more room for fee arrangements other than hourly rate going forward.
Especially with the AI transition we see now.
Yep.
If we go into the apportionment of fees, and that was actually a slight surprise to me that we see more of a winner-take-it-all set up in most arbitrations now. Jake, did you have any thoughts about that? Why is that?
Well, I think possibly, and we mentioned the complexity of cases and so on and so forth. I think more and more parties are probably thinking very carefully before they request an arbitration, given that there is this criticism of how long it takes and the costs and so forth, regardless of how true those perceived questions are. But if you are going to take that step, you therefore probably are putting a lot of effort into those early phases to determine, in consultation with the council, are we going to actually go ahead with this? And if the case is such, then, well, I mean, it perhaps makes sense that if all of your claims are then or sufficient, that you are essentially walking away with what you've requested from the tribunal, it makes sense to me that tribunals are saying, well, you know, why should you then have to stand for these costs if you haven't, if you've essentially been right and you haven't acted in a way that's delayed the process or caused increased costs for the other. But I think one thing that was interesting from this report is that this is also increasing on the respondent side. And there could also be questions of counterclaims arising as well in this calculation and in this question. But it is interesting to see this trend to increased winner takes it all. And, one of the things that has been a discussion point when it comes to what the arbitrators determine in terms of the claims is the sense that arbitrators are not splitting the baby, but rather taking a decision. And perhaps this is also then being reflected in those cost determinations.
I know there are international studies into whether arbitrators are splitting the baby when it comes to the claimed amount, and where the conclusion is generally that no, arbitrators are not splitting the baby, well, finding some middle ground in the middle, but actually going, well, for the winner takes it all approach much more. And did you have the same feeling when you looked through these 221 awards as well?
Yes, definitely. This is something that is not emerging from the statistics or not from the decisions, and that arbitrators are making reasoned decisions, and that also then includes on the costs question.
If we continue on the question of apportionment of the cost, Tobias, what's your picture of this as a counsel? Because does your client get fully paid when you win?
Always,
as you always do. Yes,
always. Usually, I would say yes. Although in at least Swedish domestic arbitrations, I think especially if you have a quantum issue, I think that is also a lot of times taken into the calculation. So if you claim for too much, you might get punished. And I think, the winner takes it all rule. It's a simple rule. It could be perceived as fair. Although there are many perceptions of fairness, obviously. I think sometimes it's a little bit strange. If you lose like every procedural issue that drives costs, you lose a lot of things, and then finally you win on your fifth legal ground or whatever, and you still you won it all. I think that's sometimes strange because you have been incurring all these costs for both parties. And I think in that, like I was touching upon before, that when you don't take the full cost of your actions, when you're like turning all these extra stones, throwing everything what you have and see what sticks, and I think if you don't have to pay for that, I think that is a little bit might often be something driving costs up. So there are, as always, pros and cons, and it's a simple rule, of course. But there are those. It might have a cost driving effect.
May I ask if you are making submissions on the question of costs, will you, if it's such an example, delve into question 1, question 2, and how it should be apportioned, or will you simply will you claim for everything?
I think that is on a case by case basis, but it's definitely something that you consider doing. Again, depending on the circumstances and the context and what kind of arbitration you're in, whether there is actually much room for it, and so on.
Something that we are selling at the SCC is, of course, the Swedish way to resolve a dispute the Swedish way, and we already touched upon the how much more international the Swedish way has become. And is there a Swedish way any longer? And one part of this progress is how submissions are becoming longer and longer, and that is clear when we have a look at the SCC platform and how many submissions we see and also how long or how big they are. What are your thoughts about this? Does it lead to success for the party to have a long submission and to really throw everything in?
I think some disputes actually deserve longer submissions because they are more complex. But I would be careful to create long submissions just for the sake of it. I think also that you can make the important points drown in all of the text, so to say. So it's better to be, in my opinion, to be pertinent and to the point. But I think Swedish arbitration has a history of being efficient, known for being efficient and pragmatic and, of course, neutral. And sometimes I can see when we, on the one hand, become more and more internationalized, adding many international habits and perhaps also creating longer submissions and more document production and so on and so forth. Are we losing a little bit of the Swedish way? And how can we keep the cake and also the cherries in it, so to say, and not to become less Swedish in our way of conducting arbitration?
No, I agree. Tobias, any thoughts on this?
Yes, I think, like we touched upon before, one reason for writing longer and with more documents, it might actually be the disputes may be more complex, or you just may have more information available. And one thing I just thought about when walking here is maybe like, how is the standard of proof affected by available documentation that you did not present? So you might not dare not to do it. But also, I think generally, I mean, yeah, it might maybe just the general not being pertinent enough or brief enough. But I think also if counsel are writing longer briefs, I think it's because they think because I think it's beneficial for the case. I think it's and it's probably an international with an international inspiration behind that, with the theory of the case and like rhetorical developments. But I do think that it's often seen as beneficial. Otherwise we would not be doing it, I think. And also if the other party does it, you don't dare not to do it. Basically, it's and then you thought you had agreed to a fist fight in the alley, and the other party comes with a knife, so you have to do the same. It's sorry. What could be done about that? I think it again goes back to apportionment and reasonability of costs.
Something else that very much drives cost is whether you choose one or three arbitrators. And under the SCC Expedited Rules, you will always only have one arbitrator. But under the SCC Arbitration Rules, you could have either one or three arbitrators. And what I hear a lot when I speak with the companies are more or less reasoning like, well, if we go into an arbitration, let's do it properly. Let's go for the full board, 3 members, the full team of legal representation, and so on. And then let's take the cost. Then when they do take the cost, they are a bit unsatisfied because it was really expensive. And something we saw in this analysis was that the result is similar between the 3 and 1 arbitrators, of course, and something that we would like to lift to parties to really think about the possibility of having 1 arbitrator instead, which not only will not cost as much, but also shorten the duration of the arbitration. And maybe this is a question to you, Lotta. Any thoughts on that?
Yeah, I've reflected a bit on that because I think that mainly the expedited rules, they are well used and accepted within the Swedish community. But seeing from your results, Jake, perhaps they could be even more presented to the international community and I can understand that users can be a little bit skeptical and afraid of using the expedited rules because, as you say, when you go to arbitration, you want a real full scrutiny of your case and to want it tried by 3 arbitrators. And can it really be as good as of a result using the expedited rules? But we saw also from your statistics that based on the pool of cases that you examined, actually the success ratio was similar between, even slightly higher for the expedited cases than the cases tried under the usual rules. So I think parties could have more information, or it would be beneficial to them to have more information about alternative ways to solve disputes within the SCC and how that can affect costs. I mean, of course, then you have the page limit of the submissions, the number of submissions, and there's much more faster procedure, which will, of course, then also impact the counsel fees.
And I think that's really interesting as well, because with the expedited procedures, we call it a front loading of the case. So in the beginning, the request for arbitration is also the statement of claim, and then the answer is also the statement of defense. So there's probably more in the beginning, therefore allowing the arbitrator once appointed to hopefully get into it as quickly as possible and then be able to come to a decision. So I don't know if that's one other aspect that, you know, when you're considering between the two, how to also be able to better with the planning, how many hours will be needed and so forth.
That's a really good point. And I think also that's also why I love the combination clause, because then you can trust that the SCC knows when the case is too complex, because of course cases can be too complex for the expedited rules and it's not suitable for all, but I think they could be used to a greater extent.
And we do see cases handled under the expedited rules that are not suited for those rules, and they tend to drag on a bit too long.
I think I agree with that, and I think normally the expedited rules gives you a very cost-efficient and time-efficient arbitration. And then with the combination clause, you're at least a little bit safeguarded against the negative effects of it. But I must also say I do believe in the theory of the crowds. More people, if it's very difficult or complex or very important, I would want a 3-party or 3 arbitrator panel for sure. But of course, depends on the value of the case.
It always depends.
It depends.
That's the lawyer's answer. And what we see also is, of course, that international disputes at the SCC, they tend to go to 3-member tribunals because you want to have your own your own arbitrator coming from your country in that panel together with 2 more.
And I think that reflects the general perception amongst users that appointing your arbitrator is one of the most important advantages of arbitration. And that is reflected in when we're looking at the statistics for the cases decided under the arbitration rules that are in the report, that I think it's a 2-to-1 or greater ratio in terms of sole arbitrator to 3 arbitrators making these decisions. And of course, the amounts in dispute will generally be larger, and of course, the fees tend to be higher as well. And that, of course, makes sense. The cost of the arbitration will increase when you have 2 more people on the tribunal.
And it will add to the number of days it takes.
Exactly.
So any last thoughts? What can we as an institution or other institutions administrating arbitrations, what can we do help you to manage costs?
Honestly, I think what you're doing today is really helpful and really good, being transparent about the statistics and informing the users. And also the cost calculator is really a good value and that you actually tend to stick to it. It's no surprises of extra fees usually in an arbitration under the SCC rules. So that's I think flexibility, transparency in the costs in relation to cost is most important for my behalf.
Yeah, I agree with what Lotta says, and I think also like developing tools like the SCC Express, which actually would maybe give you this the fist fight in the alley version of justice. No, but you might just want to have a quick answer, and I think that is a good option too for those cases.
In 3 weeks for a fixed fee.
Exactly.
In the alley.
And it does work. We have seen it a couple of times now. No, it does work. So something else that we can see is actually driving cost quite a lot is if you have, for example, co-counsel, you have different languages in the proceeding, you have a seat somewhere exotic maybe. Any thoughts on this? Because you are in the position where you negotiate dispute resolution clauses. Do you have any thoughts on that?
Yeah, I think it's a good question, and something that you also need to think about early on when creating the contract, to have both a material substantive law and procedural law that is fit for purpose. And being in a global company, I actually prefer to place the potential dispute close to where the business is located, so not have a completely different language, so preferably English if it works, and also to think about the practical aspects of the dispute. I mean, you want to be able to present evidence in an easy way, so that's another practical issue, and also to make sure when you opt for arbitration that there is a confidentiality clause, of course, in the rules or otherwise in the agreement.
And that's a really important point, because and different institutions work in different ways, of course. So it's not for sure that you will have that confidentiality under the rules. Good.
This can be a very important question, I'm sure, for the parties, especially if you're dealing with these questions of a company, business, trade secrets, and so on. But I think it's very useful. We're very appreciative of your feedback in particular, because, of course, communication and getting the message out is so important for us. Of course, we don't want our users to have to come into some sort of a dispute process. We want to be there, though, supporting business and ensuring that should the worst happen, that they can feel that there is a reliable and neutral partner, I suppose we could describe ourselves there, to make things as smooth as possible when something perhaps not ideal is happening in business.
Well, great. Thank you all for coming here and discussing this report with us and discussing arbitration costs, a favorite subject for so very many. And thank you all for listening and taking part in this session. And if you have any more questions on the report, you find it, of course, online on the SCC website. But if you have any other questions in relation to it, please reach out to either to Jake, to me, or to the email for the SCC Secretariat. Thank you.
Thank you so much.
Thank you.
Thank you.